Welcome in to Meet Your Neighbor. We have David Groner joining us once again with the Acadiana Elder Law Clinic, talking about preparing your assets and protecting your assets for the future. David, welcome back.
Good to see you.
All right, we're talking about a will versus a trust. We've heard you talk a lot about trusts. Why could having a will as your estate lead to potential disaster?
Well, this is the problem in Louisiana. The only way to transfer property to your heirs, to your children, if you do it by a will, look what you've done. You're forcing the children to go hire a lawyer and then go through the courthouse in what's called a succession proceeding. It's time consuming, believe me, it's expensive, and if there's any hitch whatsoever, the cost just continues to go up. During that whole process, your estate is essentially frozen and nothing can happen. So if you did a trust though, their estate's already planned. The transition's already taking place immediately upon your death. There is no need to go through the courthouse. But the number one reason, or the number two reason, or whatever you want to call it, that people don't want to do succession is it's not private. This is very public. So all of your assets are going to be put on a public document that anybody can see. And nowadays, you just don't want everybody in the world to see what assets you're giving to your children and where they're located. Bad idea.
Now, some viewers may be thinking, well, I don't want to do a will, I don't want to do a trust, why can't I just donate my estate to my children? Why is that not a great idea?
Okay, this gets a little complicated, so you got to roll with me for a second.
Okay.
When you donate property to a child, you have what's called a basis in that property. In other words, what did you pay for it back when you bought it? Mm-hmm. So a lot of people say they bought a house at $75,000 30 years ago. That house could be worth $300,000, $400,000 today. Your basis is $75,000. When you donate it, you're donating that $75,000 basis versus if the child gets it through inheritance or through the trust, they get what's called a step up in basis. So when they go to sell it, they pay no taxes versus they're gonna have to pay a capital gains taxes if you donate it. Mm-hmm. So that's just not a good idea.
David Groner with the Acadiana Elder Law Clinic. If you would like to learn more about what they do at the Law Clinic, you can call that number on your screen or you can visit their website.